when you're dealing with investor funds, you need to safeguard those funds. They are gold. To think of it like, your gold casket, at the foot of your bed that's, filled with your riches. You don't want to just, leave that out there for anybody. You need to be able to take care of it, take care of your investors and treat them like gold.
Hello, hello. Ginny Bolling here with the Pivotal REI podcast. And I have Lisa Taylor as our guest. And we are at the Best Ever Conference. And we've been fortunate to meet many old and new friends at this conference. And it's a terrific way for people to find out what the best practices are, who's doing what, how people are working with all kinds of situations. It's just a fantastic opportunity to meet and do business and build new relationships. And Kim Taylor is a pivotal person to many, many, many people here. So I declare her a pivotal person. So she's going to get all that recognition. And we'll talk more about that towards the end. But in any case, Kim, thank you so much for coming on the show.
Thanks, Jay. Thank you for inviting me.
Yes. Well, so like I said, you have been somebody I didn't say this yet, but I've known you, I think it's 5 or 6 years now.
Yeah.
So you go and travel to some of the RIAs and talk to people, try to start teaching people early about compliance, which is what it's all about. Your company, the Syndication Attorneys, right?
Mm-hmm.
And you do soup to nuts. Talk about how you got into this, if you would, and about your comfort.
So I started in this business by going to a multifamily conference to learn how to buy multifamily. It was Ari Richter was the one I went to with my husband, and we went to they had their real estate training course. So we went there for the 3-day, and then we realized, okay, we're going to have to learn how to raise capital. So we went to their private money boot camp, and I actually met someone who was very important in my life. Gene Trowbridge was the attorney that was teaching that at the time. He and I ended up working together and eventually forming a law firm. And then later on, I branched off on my own. But we did syndicate some multifamily aids, my husband and I and some friends, and we owned it for 9 years. We have some other real estate. We have some vacation rentals. We're also doing some triple net opportunities right now. So we stay involved in the space. And I've built a law practice on helping people who need to raise capital learn how to do it legally and compliantly, and not have to be in fear of regulators, and also doing it fairly for them and for their investors.
That's terrific. Okay, and so now, how many clients, or how do you have any idea how much you have done volume-wise at this point?
Yeah, I've been a responsible attorney for over 500 different clients doing syndications or funds, anywhere from real estate to business offerings, all kinds of miscellaneous offerings, and total raises that we've written offerings for somewhere around 4.5 billion plus. So that's with a B.
4.5 billion. Yes, that is a lot.
Yeah, so I've been doing this since 2008 exclusively, and I've written a couple of books that have become bestsellers on how to legally raise capital. Our goal is really to do a lot of education so that our clients can position themselves as in the best possible light to be able to be credible and competent with their investors and their investors' funds, and all the responsibilities that they take on when they start dealing with other people's money.
Right. And so it's evolved even just since I got in the business. Well, I started looking at syndications. In eminent domain, I bought property from syndications, but I never thought about me being in one. Didn't know how easy it had gotten with the law changes. But now, since I got in the space or started studying up, I read Joe Fairless's book first in 2018,
Okay.
18 or 19, and started tuning in. Then you came to our RIA in 2019 or 20.
Yeah.
And compliance I tune into, I really love it because I'm in a domain. It's all about that. And so I've seen it evolve. There was a lot of people just piling into this since it's so lucrative, potentially, right? Done right. It's evolved. There was a lot of general partners, GPs, co-GPs. That got to be the thing. All these co-GPs. And it's important to understand why and how things are evolving toward the fund of funds, right? Would you speak on that?
Yeah, so fun of fun seems to be the topic of the day, and I think it has arisen from the fact that there's a shortage of good deals, and when there's a shortage of good deals, there's always people that have deals that need people to bring capital to them, but it's a really treacherous area of the law if you don't know what you're doing, and you have to do it with competent counsel who's going to make sure that you do all the necessary things you need to in order to do that legally. Uh, so a lot of people don't know that there's securities compliance on three different levels that you have to comply with when you're dealing with funds and funds. Number one, if you're going to isolate and silo your investors into your own entity, then your entity is actually raising capital and itself has to comply with the Securities Act of 1933. Regulation G, Rule 506 is usually what people choose. So you have to comply with that. And that means that your investors have to have certain qualifications. You may or may not be able to advertise for them based on how and which exemption you've selected, and you have certain disclosure obligations. So you're required to give them all the material facts they need to make informed consent before they make their investment decision, and you have a fiduciary duty to them to treat their money better than your own. So part of that is now if you're directly investing in your own deals where you're going to be actively operating in business, actively operating your own real estate business, or if you're into real estate mortgage business where you're putting liens on real estate and you're raising capital for those things, then you're okay. You don't have to go any further. But when you start to invest in other people's securities, so when you're doing your own offering to your investors, where investors are buying securities in your offering in the form of LLC interests, maybe you have promissory notes, something like that, you're going to have some contractual obligation for those investors that they're going to sign. Typically, it's going to be LLC interests. And then those interests by themselves that you're selling to your investors are securities. Now, your company has put together a group of investors, you're going to go buy securities from somebody else in the form of interest in their company. When you start buying securities, then you now, as the leader of that group, are being cast as an investment advisor. You fall within the definition of investment advisor. That opens up some new regulations they have to comply with. So one of them that we have to look at is, are you being treated as an investment company? So there's some exceptions to the definition of an investment company. We always want to try to fall within one of those. So the first two I mentioned, operating business, you're actually owning and controlling the real estate, owning and controlling a business, or you're doing real estate mortgages. Those are two exceptions from the Investment Company Act. They don't require you to go any further. There's two other exceptions to the Investment Company Act for people who are buying securities. So in that case, you have to qualify under one of these other exceptions. 3C1 is one of those exceptions, and it allows you to have up to 100 investors. There's another one called 3C7, and that one allows you to have a higher number of investors. It's up to like 2,000 investors, but they can't be just accredited. They have to be qualified, and that means they have to have over $5 million in assets. So it's a little harder test to me. So most people try to qualify under this 3C1 exception. Well, 3C1 now puts you in a different light. You're not an investment company, but you are considered a private fund. And as a private fund, now you have to follow rules of the Investment Advisors Act. So the Investment Advisors Act says if you're going to be an advisor to a private fund, you must become an investment advisor. Until you get to a certain level of assets under management, then you can qualify at your state level. Your state still may require you to file a form with the SEC, which can be somewhat burdensome. Notifying the SEC, hey, we're going to be an exempt reporting advisor. We're underneath this level of assets, so we're going to just report to our state. So now we have to look at what state you have a primary office in. Once we know what state that's in, then we can look at the rules that that state requires you to follow. Usually they want a copy of that form you filed with the SEC, but then they're going to have their own forms you need to file. And some of them may require you to take a test and get a license. Some may not. And some may have some certain exceptions that apply to you until you get to a certain level. So we always have to look at that, and you have to understand that that's a rule. If you're going to be advising your investors on what to invest in, you are going to be considered an investment advisor. Even if your investors are picking and choosing their own deals, it doesn't mean that you're not going to still be considered an investment advisor, because you are still the one that's finding and conducting some due diligence on those deals. The other danger with fund of funds is that you really need to understand the deals that you're offering to your investors, meaning that you have to underwrite them yourself. And you need to learn how to underwrite. It is critically important that you do that, because the SEC has said in the past that even broker dealers can't rely on just the sponsor to provide information, and then they put their clients in there, and it doesn't absolve the broker dealer of having conducted due diligence on behalf of those their own investors. And you, as an investment advisor, are also going to be held to that same condition. So it sounds easy. It's not as easy as it sounds, but it's not impossible. So you can do these things. We have some clients that have done this. They said it's not that hard. We were able to get set up fairly easily. It did cost us a huge amount of money. We had to file some paperwork and some forms. They happened to be in New York. They said we never got bothered by the state. We did our annual records. We had people reviewing our marketing to make sure that it was compliant and those kinds of things. So you just have to realize that it's not just the Securities Act of 1933. There's more. And as long as you take the steps needed to understand what those additional rules are, then you're going to be in really great shape.
And have an attorney with you the whole way.
Yeah, you need to have an attorney that understands, number one, that you have to do it, and number two, to how to help you do it. So that's a service that we can offer. We do have compliance attorneys on staff. We are doing compliance work for other clients, ranging from, smaller operators to high profile companies, where we're helping make sure that they do comply with all of those rules. It's because it's not. So once you are a private fund, you also have to comply with what's called the marketing rule for private funds. And there's some crazy stuff in there, like, prohibited words, things that you think would be just ordinary words that you would expect to be able to say and they have. You can't. You can't use the word proven track record. You can't, say things that, like things that create a sense of urgency. You're not allowed to do that. And, you can't, it's like they've objected to things like, showing a golden egg at the top of a tree, because it's considered to be some kind of a promise that you're going to, produce golden eggs, which is just insanity. But that's how crazy that it gets. And it's not just the SEC that might be looking at what you're doing. There are 50 state securities agencies, each of who could look at you. If you have investors in those states, then they have jurisdiction over you and your offering, and they can start looking at all of your advertising and everything that you're doing. Also, you have threats from disgruntled investors. If you bring your investors into a deal, that deal happens to fail, then your investors first look at you. Well, you're the one that brought me to the deal, and then they're going to start looking at what kind of due diligence you did to make sure that was a sound deal before you put them in it. And so all of it starts to cascade, and you could get caught in the middle there. So you just want to be careful. I mean, the ramifications for doing it wrong are you could be banned from the industry, never raising capital again. You could be labeled a bad actor. You could be labeled as unregistered investment advisor. You could just, not be able to continue the way you're doing, because your reputation is instantly maligned. And from then on, you're always going to have to talk about the fact that, hey, I got in trouble for this, and here's how I worked it out. But it's a stain on your record. So just be careful. Now, fund of funds can work, but you have to realize that you are now helping people invest in something. So you really, really need to know whether it's a sound investment, whether it's a good idea for them. So you got to know your investors, you got to know the sponsors, you got to know the deal, and you need to make sure that you do all this compliance work so the deal is not at risk.
That was terrific. So let me go back on a couple things. One being repercussions. If you really are not paying attention, it could be as bad as being arrested and go to jail, right?
Yeah, typically the people that end up getting arrested and go to jail are people who steal money. So if you don't have a very clear accounting, where you can show, or you're potentially, commingling, you're withdrawing money from the bank account and using it to buy cars and homes. Uh, when I see the complaints from the SEC, they usually read like this. These people acted as an unregistered investment advisor. They bought expensive cars, took expensive vacations, and bought expensive homes. And then they bragged about it on social media. That's how they got discovered. Because as they were bragging about it on social media, their investors were looking at that going, wait a minute, I'm not getting paid. How are they doing this? And a lot of them end up engaging in Ponzi schemes because they get caught up in we're going to make money. And so they start spending it. And then the next thing you know, they have to bring in more investors in order to pay back the earlier investors. That's your classic Ponzi scheme. So the whole thing can have a really dire cascading effect. And I don't think anybody starts out trying to break the law. I think everybody starts out thinking this is, a business. I can help my family. I can help my friends. I can, maybe earn a living at the same time. You have to be careful about, putting yourself at risk. Also paying attention to your partners, because you don't know, everybody that has access to the bank account could withdraw money at any time. And maybe it's just even ATM withdrawals that they start making. And usually they'll start doing small things. And if they're not discovered, they'll keep doing them until they get bigger. And, everybody thinks, oh, I'll just pay it back. And then they don't have the money to pay it back. And then they justify how come they get to keep it. I worked harder than everyone else. So there's this whole thing called a triangle of fraud. So you really just got to be careful. When you're dealing with investor funds, you need to safeguard those funds. They are gold. To think of it like, your gold casket, at the foot of your bed that's, filled with your riches. You don't want to just, leave that out there for anybody. You need to be able to take care of it, take care of your investors, and treat them like gold, and treat their money as it is gold.
Right. And so, insofar as those who want to be a fund manager, then we need to be underwriting, and we need to be able to show that we have done the due diligence that we claim we are doing.
Yes.
And in my world, former appraiser, that means you have work products.
Yes.
So you should keep a file to prove that you've done all of it that you did do. And is there a term for what that is? Is it work product, or is there?
Yeah, you just have to keep records. Just like when you're talking to investors, you should be keeping records of all of those conversations. Every time you send out an advertisement, every time you send out something on social media, you need to keep track and keep records of that. Whatever due diligence you conduct on the asset that you're trying to get your fund of funds to invest in, you need to be able to produce that. I went to the site, here's my analysis, after I looked at their numbers and I ran this analysis. You don't want to just take whatever they produced and just say here, and just take it for face value. You got to look at these numbers yourself. You got to scrutinize them and look at it. What's missing? Is there something that should have been added in that's not? Are these numbers realistic? Are their projections realistic based on the numbers I'm seeing here? And always adding in the uncertainty of the market, what could go wrong. We never like to see deals where people are saying, we're going to return your money in 5 years and you're going to get a 17%, average annual return. And because the only guarantee in that whole deal is that you won't hit those numbers. You won't return their money in 5 years and 1 day. And your return is going to be somewhere between, 15 and 18 maybe, but it's not going to be exactly 17. And so we always, we want to talk about ranges and projections and targets and goals, not we will. You even have to be careful about saying things like, we do quarterly returns, because you may not be, if you are a fund of funds manager, you invest in somebody's deal and then that fund doesn't provide a return because they had something happen at the property they needed to use the money for, then you've lied if you told your investors that you were going to give them quarterly returns. So we say things like we schedule quarterly returns.
That's so important.
Yeah.
We're coming up on the end here. I'm afraid this is so good. What would you want to be the main takeaway for your listeners?
Securities law is not insurmountable. There's some rules you have to learn, but I always liken it to driving the car, right? You have to learn how to operate the vehicle. You have to learn how to comply with stop signs and traffic signs and speed limits, all that stuff. And you also need to know how to get from here to there, right? So wherever you're going, you got to have a map, GPS, something to help guide you along the way so you know where to make your turns. And securities laws is much the same way. You need to learn and understand what securities laws apply to you and how to comply with them. You need to have a compliance culture within your group where it's compliance first. We care about our investors. We're going to make sure that we comply with the laws in all ways, because those laws are designed to help investors and to protect investors. And so if you develop that compliance culture in your group and all the people on your team, and you keep out the people that don't have that, you don't want the mavericks who want to go out and do things their own way and they don't want to learn the rules and they just want to do some novel approach. You better be cautious about that.
Good. Yeah. So it protects you.
Yes.
It protects everybody. So that's terrific. So as I do with everybody, towards the end of our show, I ask if there's a pivotal person or event that's brought you to where you are today or pushing you towards some goal.
Yeah.
And I am going to repeat, you are a pivotal person yourself.
Yeah.
Because you make a difference in a lot of people's lives. You really change whole lives. So is there somebody or something for you?
Oh yeah, the most pivotal person in my life within this realm was Gene Trowbridge. He was my mentor, and Gene is an attorney, a securities attorney in his own right. He was here at the Best Ever conference. I got to hang out with him, which was super fun. I've known Gene since 2007, and he was the one that opened my eyes to the world of securities law, and mentored me so that I can become the pastor that I am today, and causing me to take this trajectory, because at the time I was deciding what area of the law I wanted to practice, and when I found this, I did all in love with it, and decided that this would be my track. So
And you're a natural. You are. You fit right into any conversation I know. So but tell people how they can reach you.
yeah, so the best way to reach us is go to our website, syndicationattorneys.com. While you're there, there's a schedule a consult button. You can talk to our business development director. She's phenomenal. And or if you want to schedule a paid consult with one of the attorneys, you could do that right there. And we'd be happy to talk to you at any time about any of this. We do offer some legal fees. So we do have a flex fund package that allows you to do the fund of funds model. And then we also have an add-on for helping you set up that investment advisory practice that you need to, depending on what state you're in. We'll help you research what those requirements are so that you have full understanding before you undertake it.
And one thing I want to add, I believe you all even start at people's websites, since that is the front door to a business.
Yeah, you've got to have the right disclaimers. You don't want to use prohibited ad words. You want to have the right disclaimers, and you need to make sure that your website accurately describes what you're doing. If you're describing a promissory note offering, yet you're offering people interest in an LLC, well, that's a disconnect. And, web designers don't understand the difference. So sometimes they get the terminology mixed up. We always want to make sure that you're using the accurate terminology that reflects exactly what you will be doing, really fully explaining to the investors what's going on so that they understand who you are and what you do and what your mission is.
All right. So tell people how they can reach you.
Yeah, again, go to syndicationattorneys.com, schedule a consult there, and we'll be happy to talk to you.
Very good. Thank you, Kim. Appreciate it.
Thank you, Jenny.